without further ado, let's hear it for Roger Royce, founder of Royce Law Firm.
Okay, thank you. I don't know, I could use a little more ado. How about you? All right, I guess no more ado. So thanks for having us. It's great to be here. Tonight we're going to talk about startup basics, legal strategies for success. We have 3 speakers here tonight. I'll be the first one. We're going to do this sequentially, 20 minutes each. I'm going to talk about some of the corporate and tax issues that you as startup entrepreneurs and founders want to deal with and confront. Ashith will talk about some of the IP and possibly employment issues that, that you run across when you form a company. And then Steve Colby, our patent lawyer, will talk about IP and patent issues. Now, let me take a wild guess and say that most of you are startup entrepreneurs. Is that right? How many startup entrepreneurs in the group? Almost everybody. Okay. And technology, of course. So we're going to gear our presentation towards you. So I just want to go through a handful in reverse order of priority of some of the things that you want to think about when you set the company up. And we do this presentation a lot. And I like to tell people that there's really 3 things. There's like a startup company triangle when you want to have a successful company, at least from the legal side. And if you want to have really good legal bones, you really need to have these 3 things. And as a business side, you're thinking of them as having people, having money, and having technology. Those are the 3 things. The legal issues around those are really important in the structuring. And I'm going to kind of focus on, keep those 3 points in mind. And if you think about it, think about every good company there ever was. It really had those 3 things, right? It had good investors behind them that supported them all the way through. It had good technology, and by technology, I don't mean just patents. I don't mean just patents. I also mean the know-how, the relationships, the marketing savvy, whatever it is. And of course, no company ever got anywhere without being able to attract and retain and motivate really good people. So let's start off with one of the first questions that I'm going to ask you when you come into my office and you say, I've got this idea for a startup company and I want to form a company. One of my first questions, in fact, probably my very first question will be, well, where do you work now? Are you employed now? Do you have a full-time job? And if the answer is yes, if you've been doing this on nights and weekends, then I've got 3 questions for you. It's a rule of 3, Stephen Jobs, right? I said, I'm going to ask you, number 1, this idea that you have, this company that you're starting to form, did you develop this on the company's computer, okay? Or are you using the employer's facilities? If not, did you develop it on company time, right? Did you do it during the hours that you were supposed to be working? And thirdly, is the thing that you've now created and you're going to go out and promote as your new startup company, is that the thing you were hired to do for your current employer? Because if the answer to any one of those 3 questions is yes, then we've got a big problem, okay? It means you probably don't own your technology. At best, you have a license to it, and your employer has a license to it. And we could spend a lot of time talking about all the interesting legal issues around who really does own it, but as a practical matter, you're dead on arrival as a company because nobody's going to want to fund an argument. Nobody is that intellectually interested in the very interesting legal answer to that question that they're going to want to spend a couple $100,000 finding out. So, number 1, it's got to be really important that you can claim ownership to your IP. Remember, then that's one of the 3 points of our triangle here is technology. And IP ownership is really an important part about that. Steve's going to talk later about strategy. But from my standpoint, let's make sure that what you're doing, you have the right to do. So let's move on to a second piece. Very early in your, and by the way, let me pause on that, just talk a little bit about, so let's suppose that the answer to all those questions is no, I did this on nights and weekends on my own computer at home. Let's just suppose that that's the answer, because that's the right answer. Well, we want to make sure that everybody else you hire in your company can also make that promise, that nobody brings anything over from a prior employer. And then we want to make sure that we assign all of the rights to your new company that you're about to form. Okay, let's move on to the money part of this just briefly. And you know, I talk about this just because there's so much going on in securities laws right now, and there's so much attention being paid to some of the new types of securities offerings that you may have heard about, crowdfunding in particular. And it's gotten so easy now. You can go online, you can go on LegalZoom and all these forums. You can go on, you can get investment contracts. You can write your own certificates. It's like, why do you even need a lawyer, right? Someone gives you money and you just write them a little piece of paper and you give it back to them. So I can introduce you to people sitting in jail right now who took that approach. The securities laws are really complex. They're extremely complex. In fact, lawyers regularly get this stuff wrong. You know, it's not the kind of thing you want to mess around with. And I know normally you think that, well, gee, if I didn't have any bad intent, bad things shouldn't happen to me, right? If I didn't take the investor's money and, you know, go to Mexico with it, you know, and have a big vacation, then I should be okay. And that's not the way it works. It's not the way it works. You can get in big trouble over securities law violations for relatively minor things. That's just the way the laws are set up. Seller beware. There's a rule with securities laws. So if you're taking money from somebody, you really do need legal counsel. And the reason why is because they have to fit within an exemption from registration. Security has to be registered, and unless you're doing an IPO, it's probably not registered. So it has to fit within this exemption from being registered with the SEC, and that's a fairly complex analysis to determine whether it is or not. And then you have to comply with the laws of the state where that person is sitting. But that's not where people usually get in trouble. It's over things like material misrepresentations. There's something they didn't tell the investor, or there's something they said that wasn't 100% correct. Or the one where, and this is the real sleeper, because I've seen, in fact, in my career, I have seen 2 people go to jail for this one thing. They didn't keep good records. And when the dust cleared, they ended up selling more than 100% of their company. I've seen that happen twice. Now, you might think about Bugsy Siegel and the Sands in Las Vegas and say, well, they must have been gangsters. They're out selling 2 times their company. They weren't gangsters. They were just really sloppy, you know, record keepers. When they added up all the numbers, it was more than 100%. And the investor said, well, you lied to me. You know, you told me I was getting 10% of this company, and I can't possibly have 10%. You know, it's how math works. And I know of 2 prosecutors that decided that was good enough to go prosecute them. And both of those guys, I knew them both. They did not use the money for anything personal. They put it all into the business. So this is really tricky stuff. Now, the reason I'm pausing on this is because you've heard about crowdfunding. And you can go online, and there are several very good sites. I've done dozens of crowdfunding deals where you go on an AngelList type site where you take money from accredited investors. But you need to be really careful about that, because people think, oh, well, I can go sell my stock on the internet now. No, you can't. You can't. You can go through a crowdfunding site, and you can hope that they get it right. And the accredited only sites, it's not that hard to get it right. It's a relatively simple exemption. But the kind that are now legal under the Jobs Act, where you've probably heard about, where you can take up to $1 million in $1,000 increments if you want, those are enormously complex in terms of compliance. Or I shouldn't say complex, but difficult. They're expensive, and they require a heightened level of disclosure. They require oftentimes audited statements. And there are platforms out there. Some of them are very reputable by people that have done this for a long time in the accredited arena, who I think are probably going to get it right. And there are platforms out there that were just formed by people who I don't have any confidence are going to get it right. And you don't want to be the company that lists on that platform. So be really careful about crowdfunding. Make sure you're with a reputable site that has done dozens of deals already on this, because you could end up in trouble over this. I want to talk about 409A. This is a tax thing. Has everyone heard of 409A? I'll show of hands. About half of you have. So what this is, there's a tax rule that came along about 10 years ago that it provides that whenever there's a deferral of compensation, if I earn money in 1 year, if I work for you and I earn money in 1 year and you pay me in another year, that's a deferral of compensation. And Code Section 409A, it's a tax provision, says if you're going to have that sort of scenario, you have to jump through all these hoops and meet all these requirements. You've got to have a written plan. The amount has to be payable on a certain event. You know, there has to be a distribution plan. You have to consent to it before it's deferred, on and on and on, okay? So that's the rule. It's a very short statute, and the regulations are about this thick. The statute's about that thick. So it's a simple rule, complex regulations, and it is probably, you know, the hardest thing to deal with, to comply with. And here's how it comes up in your business. Scenario number one, you've been working really hard in your company, and you've got some other co-founders, and you're putting in nights and weekends, and you're working really hard, right? And you're not getting paid because there's no money to pay you, but there's a financing down the road. And suddenly you get the idea, hey, you know what? I should get paid when we get financed. They should pay me for all this work I did now, so I'm just going to make a little entry on the financials that says I'm owed this deferred compensation, and then when we get financed, all my back pay. Well, one, no, you're not. Most investors are not going to let you do that, but sometimes they will. Okay, so it used to be worth a try. But number two, if you do that, you may be creating a huge tax problem for yourself. Now, there are ways to make that work, okay, but they're formalistic, and it's not intuitive at all. So, for example, if you say, I'm going to get paid on financing, but only if that financing closes within this period of time, okay, well, that probably works, all right? Or if you say, I'm going to get paid, you know, on this date, whether or not we have a financing, then that probably works. But to just leave it open-ended and say, someday I'm going to get paid and it'll be whenever we get a financing or maybe sometime after, that doesn't work. That's going to create a tax problem for you. So be careful about that. Be really careful about that. Second place, and that's number two, non-qualified deferred comp. The second place this is going to come up for you is going to be in the stock option scenario. And you know, in this valley was really built on equity compensation. It was really built on stock options. And everybody in this valley knows what a stock option is. I remember when I first moved here in 1991, one of the first things I did is I went down to the Black Watch in Los Gatos, which at the time was kind of this rough biker bar, and I walked in and I sat down, and there's these two guys with leather jackets and chains sitting there, and I'll never forget this, and I was just kind of sitting there and I overheard them, and one guy said to the other, and he said, hey, make sure you get equity. You know, everybody in this valley knows about stock options. So you're a startup company, you don't have a lot of cash, you need to incentivize people, so you decide you're going to give them stock options, right? Well, the problem is if you do that, that's fine, you can do that. You have to get a valuation. And those valuations are generally expensive. Price is coming way down now, and you can use some of the other services that are really dirt cheap, but it still costs some money, and a lot of startups say, I don't think I want to get a valuation. And then they'll go talk to some people that'll say, well, geez, you're just so early, you just formed a company, you don't really need a valuation. I'm telling you, you do, because if you're wrong on valuation, you've created this. Now I haven't told you what a 409A violation, what that means. I've told you what two of them are. Right? One is like trying to defer your compensation to get paid when you get financed. The other one is not getting a valuation when you grant stock options. If you get this wrong, you have to pay tax penalties. And the penalties can approach 100% if you wait long enough. They're about 80% state and federal and go up because there's interest on top of that. So it's a really big problem to have. So, you know, the takeaway here is that that's fine to have a cap table where you grant stock to your founders and you agree to give options to everybody else, but you can't actually grant those options until you have a valuation. So be careful about that. I'm going to skip ahead a little here, and I'll let Ashitha come back to the trademark issues. Invention assignments. So it's really important if you're a technology company that the company be able to say that it owns its IP, it owns its technology. And this is a problem that we see sometimes, and paper is so important, you know, in the legal world. Even a little bit of paper is way better than no paper. And one of the things you always want to make sure you do is everybody who touches your IP, they should be signing to the company an assignment of all their rights in that intellectual property. It's really important. So that's the invention assignment. If they don't do that, if you have a contractor, for example, you go hire a consultant to help design your website, or somebody does some code, if they don't assign all of their rights to the company, they might have rights in that IP that they created. You know, it's a non-exclusive, maybe limited right, you know, maybe it becomes part of their tools. But the problem is you cannot go out and represent to your investors that you own the IP because somebody else has rights in it. So that's a huge problem. So always get those invention assignments. Ashitha, do you want to tell us a little bit maybe now about the trademark issues?
I guess the trademark is also very closely related to what Roger's talking about. And what I'd like to point out about trademarks is that any kind of trademark protection that you do get is very jurisdiction specific. What that means is if you get protection with the USPTO, it doesn't mean that you're protected in, say, Europe or in Asia or in Africa or any other market that you think might be a good place for your startup to launch and, you know, basically use that market as well. So what I would say is anytime you're thinking about IP protection, the things you need to think about are A, do you have invention assignments? Because that's the first basic thing that you need to do. And the second one is that if you're going to file for patents or you're going to file for trademarks or you're going to file for any kind of protection with an agency that gives you the protection, remember that you need to figure out what your target market is. If you're launching in the United States only, then great. You know, you want to go to the USPTO and they will give you, you know, the way to do that, and then you can do that. If you decide that you're a product that's global and that after the US or maybe simultaneously with the US you're going to be launching in other markets, then you need to look at that as well. Now, trademarks specifically covers a number of things. I'll just be brief about this, but it does cover the logo, that's just the name, or you can even get the entire logo. So, you know, the design, the color, the background, all of that can be protected. So you need to figure out what kind of protection you need and how much detail you need to spend. And remember that registering your entity with the state does not mean you have a trademark protection over the name, because these are two separate entities. What I mean is if you incorporate your company with, say, the state of California and you have a name for it, it doesn't mean that that name is protected by trademark. It's possible that somebody else applies for a trademark with the USPTO and they have it. So if you're looking at brand protection as a startup or as a company, you want to look at the whole portfolio. So the IP portfolio, out of which trademark is one of them. Roger, you want me to continue? All right. Okay, so let's do California wage and hour laws. So when you're a startup, you decide that you need help from people to build your product. And you go out and you hire people. Now when you hire people, you say, okay, you know, if I hired this person as an employee, then, you know, I need to pay them hourly rate, or they're going to be subject to California labor laws. So let me do this. I'm just going to hire them as a contractor. So that way I'm not subject to these labor laws. Guess what? The problem with that is that you really need to treat this person as a contractor if you're going to claim that they are a contractor. If not, they will be subject to the hourly wage laws, the California wage laws, which means you have to pay them whatever, $8, $9, $10 an hour, depending on what county you are, you know, what state you're in, which part of United States you're in. If not, they will have a claim at the end of it that you have not paid them for it. unless you're doing a deferred compensation, which Roger just explained, you need to go through a formal, 409A specific deferred compensation plan. But otherwise, you will be subject to the California wage and hour laws. Remember that if you are employing contractors, you might not be subject to this, provided that you're actually treating these people as contractors. So you don't have set hours for them. You sort of give them an end goal and say, okay, you need to get to that end goal, and I'm not really defining how you get there. You can work 2 hours a day, you can work 23 hours a day, but I just need my result, then that might be okay. And the problem with this really is that there's no black or white between who an employee and a contractor is. The IRS, unfortunately, gives you guidelines. It tells you that this is what we would use to determine, but it's sort of gray. So if you're thinking of doing this, then I would say get help. Do your research, get legal counsel to comment on it, but be careful because it's very easy to be in violation of the California wage laws. Okay, we did this. Okay, the other thing I'd like to talk about is entrenched management. One of the things that I've noticed with a lot of my clients is they start out, they're bootstrapping and they don't really want to go out and get all the legal paperwork done. And they decide that, it's just two of us, it doesn't matter, it's just me and my friend, we go back a really long way, so we own this company. They decide what the equity split is. They probably download some forms off the internet and they have this agreement in place. Now, come 6 months, and this partner of yours decides that it's just not working out. We haven't really invested, we haven't really gotten the result that we expected, and he wants to leave. At this point, he leaves, and you say, you know what, that's fine. I'll continue working on this. And you find another team, and you go on, and then you get funded, and then, you're doing really, really well. Now, what happens at this point is that your co-founder who left after 6 months still owns the same amount of equity that he did when he did leave. And why is that? It's because you did not have any vesting schedule in place. So what vesting does is it makes sure that your team members are loyal to the company. And secondly, it rewards them for the time they actually spent with the company. So if you were to enforce a standard vesting schedule in the Valley is 4 years with a 1-year cliff, what that means is that for the first 1 year, your co-founder and you and whoever else is subject to this does not get any equity. So you have that 1-year trial period where you have time to figure out if this is the right team, if this is the right fit, if it's going to work out. And if it does work out, they get rewarded for that time with the company. And that goes on for the next 4 years or the next 3 years after that. So that's a really good way to ensure that equity is not given to people who are not really investing the same time and effort as the rest of the team who is. That's one of the ways to ensure that the management is not entrenched. The other way that we do that is to have something called a buy-sell agreement. And what that does is it ensures that the shareholders of the company are rewarded for their skill and expertise. And if one of them were to leave, or if one of them were to become disabled or die, then their equity share can actually be bought back by the company or by the shareholders. Because what you don't want happening is your co-founder suddenly is unable to provide the services for one of the reasons I mentioned, and then that stock that that person owes goes to his son or his daughter or his family because of the laws of intestacy, or because he's not able to provide, he's not able to give you the services because he's disabled, but he still owns it. So what happens at that point of time? It's really not fair to the company to let somebody own a substantial portion of the stock if they're not investing either their time or their resources or whatever they agreed to in the beginning. So we make sure that we enter into these agreements right in the beginning of the company's existence, or sometime soon enough, so the company does not have an entrenched management, because this is one of the things that investors are really turned off by. They don't want to put money into a company, or they don't want to acquire a company whose management is so entrenched that they can't remove them if they have to. So we really need to think about this in the beginning and when you're structuring the company. lack of corporate documentation. Roger did touch upon this briefly, but I don't think there's enough examples in the world to, to tell you how bad things can get when you don't have corporate documentation. Oral agreements technically are enforceable, but it's so hard to prove it that unless you have something that's in writing and that's actually structured accurately, it's very difficult to go back and undo it. And we've had several clients who've come to us, they've tried to DIY this thing themselves. They've tried to use forms that they've used in a previous startup that got acquired or that was successful and copy and pasted that into their new company, but it just does not work. You need somebody to help you figure out exactly how this is done. What does the par value of stock mean? Does it matter that the par value is different from the fair market value? How much are you paying for the stock? What does that mean to you as a tax consequence? And if any of your co-founders or your team members are international and they're not US persons, then tax is a big aspect of that. And the corporate document is a big aspect of that. And one important thing that I would like to tell you with respect to corporate documentation is remember that you do not own any stock in the company unless you have a piece of paper that says so. You could have an agreement with your co-founders. You could have a spreadsheet on your computer that lays out the equity distribution between all the team members, and you might be tracking the vesting, you might be doing all of that on some document of your own. But unless you have a piece of paper that's signed by a company representative and the stockholder, you do not own any stock in the company. There have been cases where people have gone on for 2-3 years assuming that they owned stock in the company, but no stock was ever issued because they didn't work out anything. They didn't have a document, they did not have a stock certificate, they did not have a stock purchase agreement. And then what happens? By the time you get to that point, your stock price has risen up to such a level that you can't really afford to pay the stock. You have to buy the stock. And if you can't buy the stock, what do? You say, okay, I'm going to provide services in exchange for it, which means that you're going to be taxed on it. So there are consequences to not buying stock in the initial stages of the company when the stock price is really, really low. So remember that when you decide to have your own company and become formal, issuing stock to yourself is an important portion of it. Okay. Roger, you want to take the tax planning?
Okay, thanks. Actually, I think I'm going to turn it over to Steve here in a minute. But just briefly, 1 minute on tax planning. And by the way, thank you, Ashitha. Ashitha's a corporate lawyer with the Royce Law Firm in Menlo Park. So lot goes into planning startup companies. They're always Delaware C corporations. And I just want to pause on that for a minute and just tell you that usually that's the right answer, but not always. And the scenario, so it's worth a conversation and it's worth thinking about whether you should be a different type of entity when we form your company. And I'll tell you why. You probably all know this, but a C corporation gets taxed twice when it sells its assets. Corporation gets taxed when it sells its assets because it's made a sale, pays tax at up to 35% federal. Then it distributes the proceeds of that sale to its owners, and the owners get taxed again. Works out to, with state taxes, almost a 70% rate of tax. This becomes a big deal when you go to sell your company and your buyer wants assets. If you use a different type of entity, a limited liability company or an S corporation, there's only one level of tax. All right, so you end up with around a 23 plus 9, around a 33% rate. So you save a good 30 percentage points. The difference, however, is that the C Corp, there's this thing called qualified small business stock that all investors want. And you have to be a C Corp in order to give that to them. And then if an investor has this qualified small business stock and they hold it for 5 years, they pay no tax on the sale of their shares. So there's always this tension, but it's worth thinking about who your investors might be and what your exit might be before just making a knee-jerk sort of selection of a tax status. Now, with that, I want to turn us over to the IP. So, the Royce Law Firm now does patents. We now have a patent prosecution department. As of about a month ago, 2 months ago, Steve Colby and Robert Hayden have joined us. They came from Peters Verney, patent law firm in Palo Alto. So we now are truly, our 30 lawyers are truly full service, including patent prosecution. And now that we have a patent lawyer, I'm going to sit back and listen all about do we need patents? Is that really important?
That is exactly the question that I'm going to ask everybody here is, why do you need patents? Any ideas? It makes a beautiful plaque. It makes a beautiful plaque on your wall, and you can get a nice colored frame, and that plaque will cost you about $200, all right, to get the good frame company with a nice mat and everything. The problem is that the patent itself costs a lot more than $200, and how are you going to justify spending 20 grand, $20,000 to $30,000 per patent to your investors? Why is it worth having that much money to get a beautiful plaque on your wall? Well, a good patent strategy answers that question by looking at the value that the patent provides to your company. All right? So when people come to me and ask me, why should I do patents, how many patents should I do, and so on, my question is, my question is always, well, what is your exit? I mean, that's the first question I ask. What do you plan to do? Do you plan to have a company and own it for 25 years? Or do you plan to get investors on and do a big IPO in 3 years and be a billionaire? Is that? And most of the time it's the second. So the question is, what kind of strategy then can you apply in order to make value out of patents? Well, the value can be incurred in two different times. First, when you're going out there and talking with investors, you're going to be telling them a pitch that says, this is why you should put money in my company, and this is why today my company is worth $15 million. And part of the pitch is that we have a protected market. We're going to be the number one in this field, whatever your startup is doing. And one of the items there is going to be that, yes, we have done our IP due diligence and we've applied for patent protection. So patents can add value every time you do a funding round, right? Now the second place where patents can really add value is at the exit. And this is the place where personally I really feel rewarded. When I have a company that sells, that's a few years old, 3 years old maybe, and sells for $350 million, I know I did my job right. I mean, of course, there was something else, they had a great product, but I know that I've done my job right because I helped create the value at the end. And when I talk to clients and I'm interviewing for them for the first time, I like to tell them, my goal is that for every dollar you spend on me, it pays back many times right away in your next round of funding. Of course, I can't really prove that, but I just try to give people the idea that that's my goal. That's what I want to do for them. I want to create value in their company right away. Okay. So now let's talk about once you've decided you're going to do patents, what do you do patents on? So my next question for people is, can I talk to your marketing folks? I don't want to talk to the engineers when I'm discussing patent strategy. I want to talk to the sales and marketing people. What are patents for? Patents are to create a monopoly so that you can sell your product and you don't have so much competition. That is the area of sales and marketing, right? We want IP coverage for your company on the things that make your product sell, okay? If you don't remember anything else, that is the one line to remember. You want IP on the technologies, on the things that make your product sell. When your sales guy gets up there in front of a group like this and pitches your product, he's going to tell people a bunch of great things about your product. And so my patent strategy, a good patent attorney is going to start at that point and say, okay, what are those things that sell your product? That's the first step. The next step is to go back one and say, okay, what are the technologies that enable that? And I'm going to give a specific example here because I'm usually talking with people in a conference room, and there's a speakerphone on the table, and it's one of those Polycom triangular speakerphones. You all know that, right? Okay, everybody's seen that phone. So I use that very often as an example. And I know the attorneys who wrote the original patents on that phone. And that attorney was an electrical engineer, and the two founders of Polycom were electrical engineers. And they wrote patents on these noise filters, and there was one on a couple of communication modules. And those filters and those communication modules were incremental improvements over what existed before, and of course have long been surpassed. So, but why is that phone so successful? Well, part of the reason is the big sound that it gives. When you talk on those phones, you can hear really well. And a good patent attorney is going to look at that and say, well, why is that? And one of the reasons is the speakers in the middle, pointed up towards the ceiling, right? And then you've got these three legs on the side where the microphones are. It turns out that really helps, okay? It's not the high-end electronics or the stuff the guys went to engineering school for. It's the placement of the speaker there in the middle so the sound goes up towards the ceiling and gets heard really well, and microphones that can then pick up sound at basically mouth level around a table, all right? And they didn't apply for a patent on that. And the attorney who did this learned. But the most valuable patent that that company had to start with was a design application on the shape of the phone, all right? They missed the doing the step of what really, when you're going to buy a phone, what is it you do? You want one that sounds really great, that has a big booming sound and picks up things with your microphone really well, okay? They didn't start their patent strategy at that point. They started it with the engineering team that said, I just made this fantastic noise filter. Well, I don't care, you know? The point being is that in your patent strategy, you need to go back to that first step of why are you doing patents? You're doing patents because it creates value for your company, okay? And then the next step is to say, okay, we're going to identify those things that really are going to make our product successful. And sometimes I'll sit there and there'll be three founders at the table and I'll say, why are people going to buy your product? And I get three different answers. And I realize that there's another problem, but you know, that they need to work that out. And that happens more than you think, because they'll all kind of look at each other and go, and come up, because they really haven't thought about it, right? So let's see, where was I? Yeah, so in a minute. So how do I make, so once you get a series of, over the years, patents are expensive, but over 4 or 5 years, you're going to build up a patent portfolio, and you're going to be doing your C round where you're raising money at a, you know, hundreds of millions of dollar valuation. And at that point, you get to the position where you want to convey how the patent portfolio relates to your product. And you've just given a pitch that says, these are the big things that sell our product. And what I've seen many people do is then they have another slide that says, and we have patents, and there's a list. And they kind of nod, and they go on to the next one. That really doesn't do it. If you've done your patent strategy right, you'll come up with a map like this. And I do this probably 3 or 4 times a year for one of my clients, okay? And this is a cluster map. And it's based on, which matter is it? Okay, so it's based on a image analysis software, okay, an app that does image recognition. And the magic reasons why people buy the product are in red, and I've listed the patents around them and drawn lines between them. And the idea is that this shows the relationship between the IP and the reasons why somebody would want to buy a product, okay? And that way you've actually conveyed the value to the investors. I've seen live this used in a pitch, and the investors, instead of just nodding at a list of patents, they go, oh, okay. And all of a sudden your valuation has hopefully gone up that much, right, in their mind, because they're going to remember this picture a lot more than they are anything else. So this is the type of product that I'll produce. And you can see with this client, we've got 1, 2, 3, 4, 5, 6, 7, 8, 9 applications, some of which are both in the US and in China, okay, in Canada. So this is an example of somebody who's probably going to spend $100,000 on patents over 4 or 5 years. And this is the type of map that you can produce if you've done things right, if you've done your strategy right. Now, that's about patent strategy, and I had some other things I wanted to talk about, and the speakers before me talked a little bit about it, but the one that I really want to talk about is ownership of your IP. Every time I ask people, even the founders, I said, is there a founders agreement? Is there a clause in there that says that you need to assign your IP to the firm? And the founders never occurred to them. Right? I have had situations where a founder dies and the wife doesn't get along with the company or anybody else. It's disasters. So ownership of the IP, especially with contractors, consultants, anybody else you might want to be bringing in, anybody who has exposure to this, is important. Another thing that I see a lot of problems with is disclosure. There's certain timing of when you want to make things public. And as a startup, you should talk to your patent attorney before anything goes public. And that means talking with investors. All right? Anytime you have a written material that you email to somebody, you should have some discussions with your patent attorney about the pros and cons and what kind of protection you can get before you do that. It can be relatively inexpensive to get some minimal protection. I'm sure Roger knows, there's great stories about things being mailed to VCs or angels, and the first thing they do is ask their buddy who's already in that field who has the same product in his company, right? So your proposal just bounced around to 3 or 4 people in the valley. So those are the things that I see most often as problems with IP. I don't know how much time I have. So is it time for questions? Okay.
Let me start off by asking you.
Yeah.
Suppose, because I've seen this happen, there's this form floating around the valley. It says, I hereby agree to assign all of my IP. I hereby agree to assign all of my IP in this particular field of use to you, the company. Okay? And this is a famous case, actually. And you're the company, and the guy signs it, and he works there a little bit. He develops some stuff. And then he quits, and he goes to work for another company, and he signs another form that purports to assign the same IP, but this one says, instead of saying I hereby agree to assign, it says I hereby assign all of my IP. So your form says I hereby agree to assign. Your competitor's form says I hereby assign, and it's the same IP. Who owns that stuff?
$150,000 worth of attorney fees later. Yeah, so that's an expensive mistake. That's that's the type of thing. So the issues, there's lots of different issues here, and you've got the field of use clause. Nope. When somebody invents something, in the United States, they own it, all right, and they have to sign an agreement giving it to somebody else, a legal document, all right, called an assignment. And there might be several inventors. One of them might be a university professor, and one of them might be based in France. All right? So you have to have a French copy of your assignment, or you have to make sure that that person can read English. And you have to worry about French law. All right? These are all the different types of issues. And there's a problem if 2 people own a patent. So a patent issues. Who owns that patent? This person said he's going to assign in a certain field of use. Well, patent's not necessarily something that represents a field of use. It could be really broad. So now you have multiple owners of the patent, which makes it unusable, basically. And now you bring in the problem of, oh, he's now assigned it to the second company, which is probably a good assignment. All right, so the first company only has a breach of contract claim against him. And that's the limit of their claim. And that person probably didn't get much for it, so he probably has a dog and an old car, and that's all they're going to get out of it. I mean, that's his assets. So getting the assignments and having talked to attorneys about the assignments is a really critical issue. And even your agreements should read, I agree to assign and I hereby assign. Okay? And that means if the person goes and becomes a Buddhist monk, that original agreement can be used as the assignment document. And that was a case coming out of Stanford, where a professor managed to had that signature, and then he signed his discovery to a big drug company, and the university won. It was because I hereby assign. That counted. So this is the rules of assignment. It can be very strict. That's one of those things you need to get, even among the inventors. In California, we have something, and I'm not a family law person, but we have community property rights in California. And that means if you're an inventor and you're married, it's community property. So there are times when the wife of inventor, he founds a company, they split up, and then the company has a big infringement lawsuit for millions of dollars, $100 million, and the wife comes along and says, well, I still have my community property rights in this. And that can kill it right there. And 10 grand, sure, it's all yours, and it's all over. So this is the type of thing that we worry about, and it gets more complicated when it's European law, which can be very different. And here, how many of you have people that are who are working for your company that are outside the United States? Okay, so are they going to sign an assignment here that's good in California? And do they speak English to do that? Are there laws in their home country? Germany's a good example that gives extra rights to inventors that we don't have here in the United States. There's all kinds of issues like that. So when something like that comes in, I talk to a Russian or I talk to a Polish or most often a French legal counsel, and we go over the assignments to make sure everything's clean.
I want to take another step back on patent stuff. Here's the other thing you hear in this valley a lot. It's like patents, what do we need those for? We'll just rely on trade secret. Kind of like Coca-Cola and that formula. We're just not going to tell anybody how we do it. Because, if I file a patent application, I have to disclose to the world, and then, big AT&T's going to get a hold of it, and they're going to sue me because they got a lot of money, and they're going to invalidate my patent and take all my, and they're going to break my company, which does happen, by the way. Big companies do that as a strategy. What do you think, Steve, about this idea that you can rely on trade secrets in order to protect your company's IP? Is that valuable? Is that financeable? Is it bankable? Is it a good idea?
There are times when I have sat down with people and the end of our meeting is, you're better off with trade secrets, maybe 1 in 50. And those are situations where the chances of getting a patent are actually pretty difficult. The last time I did it, it was for an insecticide, and they discovered a new way of creating a little polymer shell around the droplets so they could spray it in the field and it would last for months. But they knew that nobody else would figure out the chemistry because reverse engineering that was really hard. The chances of any of you having products that can't be figured out backwards is pretty small. The other thing with trade secrets is trade secrets will walk. I have had clients where I put them in a specific trade secret program, and that means a binder with their corporate papers that lists their trade secret, and everybody who gets access to the secret has to sign in that binder. This is a secret that I've been given, and I agree not to remember it when I leave. It's really hard. I mean, so many of you are probably engineers, and I spent many years in engineering, and I can't imagine something I learned 20 years ago and still remember how to do, and I don't remember whether it was a secret or not, but it's a clever trick, and all of a sudden I'm using it at my new employer. And you have to really pick your trade secrets very carefully, decide what's a secret, and make people sign so they remember it. Okay, if you don't do that type of record keeping and documentation, it becomes really hard to enforce trade secrets. Sometimes it's more obvious, like to marketing people, our customer list is a trade secret. It should say that in their employment agreement. They have to initial that. So that's the type of thing where you document it and make sure that the people who get access to the trade secret are limited, and those people sign off on in a way where they're going to remember still 10 years later, oh yeah, I can't talk about that. So it's inexpensive. It actually can have value in investments if you have documentation. Hold up that binder in front of your investors. That's the type of thing, they don't get to see it. But that's the type of thing that you need to do in order to make value out of trade secrets.
What's the difference between a patent and a trade secret? Can you explain that?
A trade secret is something that you keep quiet about. You don't tell anybody else. And there are laws in the United States that allow you to go after people who leak trade secrets. if you can catch them. It is something that it can be a mailing list of clients. It can be a chemical process. It can be some great algorithm that you're using in your software. It can be your lists of clients, of registered users. Okay, so LinkedIn considers the database with everything they've got a real important trade secret, even though they release incrementally parts of it in different ways. A patent is, in your case, is either a utility patent or a design patent. A design patent is something that you do on the shape of that Polycom phone or on the hubcap of a car, right? I've done design patents most recently on docking stations for laptops, right? A utility patent is a patent on the way something works or what it is. And so now we're in the realm of really cool software apps that do things that people wouldn't do before or couldn't have been done by hand. Or we're talking about the microcircuits in that camera back there that have a new way of refreshing the gates on the reads of the data bits, and that's a patentable technology. So most of you, including software, will deal with utility patents, which cover either what something is or how it's used. More questions? Does anybody else have any questions?
Well, we're at 8 o'clock, so I want to open this up to questions now. In the back, yes, sir.
Put that microphone on so they get it on the. So what's the difference between a provisional and a non-provisional patent?
A provisional patent is something that lasts for only 12 months exactly. And it is basically a placeholder. Think of it as a stake in the ground. And the advantages of provisional patents is they can be very informal. They can be a slide deck. They can be often a paper that's about to be published in a journal. You just take the paper, put the cover on it, and get it on file. And that says, I owned this at this time, whatever's on the paper. I've seen 2 pages of writings and scribbles. They can be informal, and that it provides an advantage because it's much less expensive. $1,000, $1,500 if you want help. Okay? There are some good books on writing provisional patent applications you can get on Amazon. They're $40. Okay? So the provisional is informal. It's good for companies that don't have any money yet. So I will actually work with companies that have not gotten money. If you have a credit card with a $600 limit on it, we can talk. So my goal, though, is that a year from now, you'll have raised money and you'll be able to afford a non-provisional patent application. A non-provisional patent application is something that's going to cost between $10,000 and $16,000, roughly. Okay, the first one will be a little more. Afterwards, they should average out under 10. Okay, so this is a very formal document written by an attorney with all kinds of legal language and claims and things like that that represents your invention. And this is the thing that goes to the patent office and gets examined, and people, if it issues as a patent, then it becomes your valuable asset. A non-provisional patent application can depend from a provisional. Think of it as a parent-daughter type relationship. That means that if you file a provisional for that date, you get credit for whatever was in that provisional for the provisional's filing date, and you get credit for whatever else was added for the non-provisional on the non-provisional filing date. And that's the real risk of provisionals. A PowerPoint slide deck is not really supportive of a lot of invention. It's usually a very high level hand-wavy thing. So you really aren't going to get much credit for that date. The danger of provisionals is you think you have protection and you don't. But they do have their uses. Like if you're going to give a public talk, or you're going to give a presentation, or you've got a slide deck you're going to send to an email to a venture capitalist, you can file that as a provisional and not worry so much that it's going to bounce around.
So is the patent, the provisional patent also issues a patent number? We can use it for pitching to the clients?
It has a provisional application.
Okay.
Does have a number, and you can also mark your product patent pending.
Okay.
which is kind of nice, as long as the provisional actually does relate to the product, right? So, but it doesn't issue as a patent. If you have to file a non-provisional within a year that references it. Otherwise, it goes away as if it never happened.
So it'll have the same IP number for when you file for a non-provisional too?
You get a new number.
New number, okay.
Hi. I just started my own company, and I have written 2 patents. They are provisional, both of them.
Yeah.
But I assigned both of them to the company. Is that a good strategy?
Yes. If I was one of your investors, I would have checked. That's one of the things I would check before I wrote a check,
Okay.
so to speak.
Thank you.
Let me add to that, because I see this scenario come up a lot. Steve's a good patent lawyer. He didn't tell you not to assign it and to hang on to it and don't give it to the investor. But sometimes that's what they say. They say, let's just license your patent to the company. And that way, if the company fails, you just cancel the license and you get your patent back and you can go use it someplace else. And that's a beautiful thing when it works. But a sophisticated investor is not going to let you get away with that. They're going to want to have an assignment. Now, I have had it happen a few times over the years where we drop the patent into an LLC and then finance it and then license different fields of use to different companies. So like I had a medical device patent that could be used for different organs, for example. Several different companies. And then we saw which, just waited to see which one. So when, the kidney application failed, it didn't drag everything down with it, and then when the next one, ear, nose, and throat application worked, it wasn't burdened by the liabilities. So it's a great strategy if your investor will let you get away with it, is the only question. Rarely. They're usually smarter than that. I mean, I say that, but I had this happen, and it was a big VC investor with a big, humongous law firm behind it, that let us do it, and that's exactly what happened. The application they invested in went broke. The application that worked ended up being a very, very big successful company. So think how silly they felt. They won't make that mistake again. Other questions? I want to pause a little bit. Ashitha, why don't we give Ashitha the mic? I'm going to ask Ashitha some questions about employment that we didn't get to. Okay.
So this one is about what if somebody is using something that I already have filed provisional patent, and a few months later they came up with a product that seems like mine.
Yeah, that happens a lot.
So what should I do in that case?
No. I'm not a litigator. We don't do so. It depends. And I literally have this situation now where I have a client that did a bunch of filings, and then iOS 10 came out. It's 8 months later. Who knows, right? The real question is, for your business, my first question is it a big competitor, and is their product just as good as yours? And what are you going to spend the next year of your life working on? And so that's the first. I spent many years in business before I was a patent attorney, and so the first question that comes to my mind is, does that make you have different business thoughts? And I would probably have a conversation with you about that. It could be that you're first. We live in a first-to-file world, okay? And if your provisionals are good enough and support later patents, then you may have the guillotine over these people's necks. I need to, and so if your company is successful and becomes a head-to-head battle, and this I have seen, 2 companies with different IP portfolios in the same space, filings within months of each other, and the investors go in and they buy the one that's going to win the IP battle. All right, and the other one, 30 days later, is sold off to creditors. I mean, it's gone. Okay, so it was a win-lose situation, and so you could go. And it'll be years before you find out who filed first. It's not a good business model, really, economically, to try to spend lots of money on patents and sue people. A patent lawsuit starts at about $1 million, so that's your budget, okay? And so that's something that really rarely works because there's so many patents out there. So yeah, you have to make the business decision now and watch them closely. and make a better product. That's my goal, is see what they've done. One of the things you can do now is look at their product and look at yours and focus in your IP on the things that are better about yours. All right? Or look at their product and go, oh, they should have done it this way too. And you'll get lots of ideas. And then write patents all around that. Because when they finally get the idea, you'll be in for them. That's a fun way of, I like doing that type of patent. It's like, let's get them, let's get them, let's get them, let's get them. Okay.
Thank
Okay,
you,
I have a
Steve.
question for. I have one question for Royce. All right, I have a question for Royce. Are these invention agreements are different from the NDAs, or? Okay, Anshul. Yeah.
What was the question again? I'm sorry.
Yeah, are these invention agreements, are they different from the NDAs, from the non-disclosure?
Absolutely, yes.
Okay.
They're very different from the NDAs, and I'll tell you why. It's because an NDA is typically a non-disclosure agreement, and that's what you use in the initial stages of your meeting with either a team member, an
Right.
investor, if you can get an investor to sign an NDA, which is probably unlikely, but it's something that you use in the initial stages, and what it does is it basically requires the person that you're meeting with to keep that information that's exchanged confidential. So what you're trying to do is basically protect yourself from being ripped off of the IP or whatever information you're sharing in that meeting by that person. So you're saying, keep this information confidential, and then I'll share the details of it with you. That's what an NDA does. An invention assignment, on the other hand, is something that you use with a person who's providing services for your company. So if they're writing code for you, or if they're designing a web page for you, or if they're doing any sort of, if they're creating any sort of intellectual property for you, and when I say you, I mean the company, then you use an invention assignment, which basically allows that intellectual property that has been created to be owned by the company. Because that's the ultimate goal, is that all of the IP has to reside in the company and not with the individual. Not with you, not with your co-founder, not with the person who's actually creating the IP, but it needs to be housed in the company itself. And that's what the invention assignment agreement does. So if you started off, let's say that you found an NDA that's really, really good, it's solid, it's vetted by counsel, and you got your co-founder or your technical person to sign that NDA, do not assume that when they actually start providing services for the company, that the code that they create or the IP that they create will belong to the company. It will not, unless you actually have an assignment agreement in hand. Sure. I think there's a mic coming up there for you.
So earlier you mentioned that for S-Corp it's a pass-through, right? Does it mean that the taxes are going to even out when I'm actually giving the salary to myself from the company? I'm going to actually make that as the company write-off or expense. When I'm getting the salary towards myself, that's going to go towards my income. So the expense that I'm writing off on the company, is that going to be equal towards the money that I'm receiving? So end of the day, is it going to be net zero, or how does it work?
You want to take that, Roger?
Generally, that's generally true. Now, I want to tell you there's this very sophisticated technique we all use with S corporations where you can avoid FICA, FUTA, and Obamacare taxes. So on the first $130,000, if you make a distribution instead of a salary from an S corp, you're gonna avoid paying like 18, 19, 20% tax, 19% now. Beyond $130,000, you're going to avoid paying 3.8% if you game it right, if you plan it right. Because all those taxes I mentioned, that applies to salary, doesn't apply to distributions from an S corp. That's fairly sophisticated tax planning. That's the kind of thing you sit down with your accountant and you plan that out. But generally, that's right. With an S corp, doesn't matter what your salary is. You get a deduction and you have that much less salary, that much less pass-through income. I want to talk about employment a little bit, Ashitha. Could you pause on this? Because in the startup world, we just see so many employment law violations, right? I mean, you got people, you're paying them in equity, you're giving them stock, right? You're not paying them cash. You're just giving them options and hoping they'll wait until you get financed. Is that a problem in California?
Absolutely. I think what we need to remember anytime you hire an employee, technically, or a contractor for that matter, is you need to comply with labor laws that are applicable to that situation. So if this person is an employee, then they are probably going to have to be paid as an employee, treated as an employee, and you as an employer have some obligations too. So you need to withhold a certain amount, you need to do your payroll, and you need to pay taxes at the end of the year on behalf of that employee. So hiring an employee is a pretty expensive proposition for a lot of startups. So what they end up doing is hire contractors. And like I mentioned in my talk a little earlier, if you're hiring a contractor, please make sure that this person is actually treated as a contractor, and he's not just a contractor on paper, but in reality, you're treating him like an employee. That makes a big difference. And what ends up happening is if you have a disgruntled employee at the end of your, say a year and a half, you don't get along with them for whatever reason, they go away, then they have a very, very solid basis to come against the company and say, hey, I haven't been paid. I was told that I'm going to be paid. I'm paid in equity. The problem with being paid in equity is that A, you don't have a valuation unless you go out and get a valuation, and B, you still are liable for the hourly wage rate because that's not an exception. So if you were to go out and hire somebody as an employee, make sure that you're paying them at least the minimum wage, which is $9, $10, depending on what county you're in. So that way you're at least making sure that there's no ridiculous claim out there which says, well, this was my market rate and I wasn't even paid the minimum wage. Do you have a question? Sure.
Lots of questions. You guys came at the right time. So basically, I planning to hire 2 people in February.
Mm-hmm.
But between now and then, they're going to start with me as interns, and we exchanged other benefits. But they're not paid. Is that okay?
Well, the problem with voluntary interns, again, is it's very, very tricky. There's a very, very narrow slice where you would be allowed to classify this person as a voluntary intern, but otherwise an intern is just like an employee. So you're going to have to pay them for the hours they worked. You're going to have to treat them like you would treat any other employee.
But we haven't signed any contract or W-2, and they're not officially employees.
It doesn't matter.
So I have a story. I'm not an employment lawyer, but I've done 2 employment cases in the last 3 years that I didn't want to do. And one of them is about not having a contract and being there, and it's an agricultural case. And have you heard this? Okay, so my family owns a ranch, and this is in Northern California. And we had a farm manager, and we did vegetables, and we're a sheep ranch, we do milk. And we had a farm manager that would go and sell vegetables at the farmer's market every weekend, two or three different times a week. And on the weekends, his girlfriend would come from the city where she lived and go with him and help sell vegetables, right? And years went by, and he was caught doing something that he shouldn't have done and was fired. And the girlfriend sued for 3 years, right? Back wages for every weekend that she had notes of all the times she went and helped out at the farmer's market. Never an employee. She was hanging out with her boyfriend. And she won. I mean, there was no defense. She was there. She actually took money, did things. It would have cost much more to fight the case than it really was. So my view is always treat them like they're employees and even have at least minimum wage. And again, she's going to be able to explain to you the difference between an intern and an employee, which is pretty narrow, right?
Can I step into this for 1 second? Because I sit in this position. So we get students that come in as interns. We still have to pay them. There is no unpaid internship. It's a very, very small, when I say small, I mean there's only a couple of industries where they still allow you to have an unpaid internship. Okay.
Unfortunately, you have to pay them like an employee because you do have California minimum wage law. So just pay them the minimum wage, whatever the minimum wage is. Sure. So your question is, if you had somebody whose market rate was $100,000, could you
Yes.
pay them minimum wage?
No. That's because the person is investing in the company as well. He believes that we all like almost working together.
Well, you're legally required.
Yes. Yeah. Okay, got it. Thank you.
Okay, when you talk about employee, you're talking about a W-2 person, correct?
Correct.
And when you're talking about a contractor, you're talking about 1099, correct?
Correct.
Okay, now my question revolves around a 1099 person versus a 1099 organization that the person works for. Is there a difference between contracting with an individual or contracting with an organization that employs an individual?
So I think one of the big things you need to remember if you're working with an organization that sends you people as 1099 contractors is you need to have each of those people sign invention assignments. It's not sufficient if you have an organization sign an invention assignment because the individual people who are working on it probably have some claim to the IP that they're creating for you. And that's one of the big things. In terms of tax differences, I'll let Roger take that.
I know where you're going with this. You're not the first person to think of this, because you're technically right. If you're paying a corporation, well, that's not an employee. It can't be. An employee has to be an individual. So you're not going to withhold. You're going to treat it as a contractor. Then the corporation, they're going to pay their people, and they're going to withhold, but that's their problem, right? It's not your problem anymore. And technically, every piece of that is right. But you do not get out of this classification by putting a corporation between you and the employee. Because the test for an employee is direction and control. Do you have the right to control that individual? If you do, he's your employee. Now, you probably know this gets way complex, but there are professional employer organizations where you have joint employment relationships, or they're leasing the employee to you, but you feel pretty good about those because somebody is collecting the wages and somebody is collecting the taxes and they're withholding, they're complying with all the rules. But if you're going to try and do this, use a loan out, call it a loan out corporation to avoid payroll taxes or even employment liabilities for that matter, wage and hour, discrimination, health benefits, workers' comp, unemployment. There's a million things. It's awfully risky. Okay?
So there are certain criteria under which you can hire unpaid interns too, right? Like if it benefits the the student's education or it's related to their field of profession.
Yeah, no, there is an unpaid intern category. It's just that everybody blows it. It's so hard to comply with. I mean, they can't do any administrative work, right? They can't do any work that you would pay your other admin people to do. It's got to be for their benefit. They're learning. They're doing this just to learn the craft. I mean, my law firm has interns too, but I wouldn't. It's just, again, lawyers are just risk averse, and I would never try because, it's like Steve says, all they have to do is raise the claim, that they did, something and that's it. You're kind of screwed. But having said that, I'm a lawyer, and lawyers are pessimists by nature. In fact, I've often said that if I were an optimist, I would probably drown in a half-filled pool. That's how much of a pessimist I am.
But what if the students really want to work on the technology but not get paid? If they really are excited about the technology.
It doesn't matter how much they want to. Welcome to California. What you want doesn't matter at all.
Hey, so you've mentioned that when the investors are not from United States, it creates tax implications. So what does it really create? What situation does it create? I'm the only person from US and there are 2 guys from UK.
You have to use a C corporation. That's kind of the long and short of it. I mean, you could use other types of vehicles, but then you end up with an increased tax obligation. And I've never seen a foreign investor want to do that. So if it's a foreign or shareholder, if it's a foreign owner, your structure will be probably a Delaware, but it will definitely be a C corporation.
Even if we plan to pay ourselves dividends every year?
Doesn't matter. Well, it does matter a little bit. If your investors don't mind being in the U.S. tax system, if they don't mind filing U.S. tax returns and having to file in California too, if they happen to be here and making all those disclosures, then you can be an LLC. It's just that I don't find many foreigners that want to do that. They want to stay as far away from our system as they can.
But then I'm double taxed.
Depends on what country you're from, because your home country should give you, this is way beyond our thing, but your home country should give you a credit or an exemption or exclusion for either for the taxes you paid here or from your income, so you're not double taxed. And the United States has treaties with, there's 160 countries now, income tax treaties to avoid double taxation. So that's usually not the issue.
Yeah, I'm from Poland, but...
Oh, I'm sorry, the C Corp double tax. Yeah, but that's right. That's right. That's exactly right. You hit the nail on the head. If you own shares in a C Corp, and whether you're foreign or domestic, there's going to be 2 levels of tax.
That sucks.
You know, yes, but the way I look at it is that there's a way, if you're a domestic person, that you can elect out of that regime and have 1 level of tax, okay? But those structures we talked about, the S corporation and the limited liability company, you won't get a venture capitalist to invest in that. They can't invest in an S corp just by definition, and they just won't invest in an LLC because their charter documents usually prohibit it for lots of reasons we don't have to go into. So really what it comes down to is that if you're in one of those companies that is just growing explosively, and you really need that money now because you got to get into the market with your app right now before your competitor gets in, and whoever gets there first is going to be the next unicorn, and whoever gets there second is going to be like that company you're talking about that gets sold in bankruptcy. Well, yeah, you'll just bite the bullet and pay 2 levels of tax and take the VC's money and then convert to a C Corp. That's how it usually works out. And everybody thinks that's what they're going to do, by the way.
So what's your exit, though, at the end?
So my exit would be to sell company at some stage.
To what?
To sell company.
Yeah, so if this lasts for 4 or 5 years and then you sell the whole company, all your stake to Sony or to IBM or whatever the space may be, then the C Corp structure is you've spent all the funds that the company made went into the company, and you probably didn't pay yourself a lot. All right, you didn't probably take a lot of dividends because you were busy investing, building that company into something huge, okay? And when you sell the company...
Oh, my turn? Well, if it's a C Corp, there's 2 levels of tax. If it's a pass-through, there's 1 level of tax, whether you're foreign or domestic. Okay, and then we're out of time.
Okay, I think one thing that I want to add to this, I know the C Corp, S Corp is a big thing that most startups really worry about when they're incorporating. But you should remember that you're going to have this problem of double taxation only when you actually make money. And in my experience, most companies that get to a financing, they're probably not going to make money in that initial phase. And by the time they get to an institutional round of financing, you have to be a C corporation because you have to issue 2 classes of stock. So your options, the S Corp would be great if you actually get acquired without getting financed by an institutional investor, which does happen, but I'm just saying that, you know, if you were to go the financing route, which most startups do, then being a C corporation would not be a terrible thing unless you actually make money and you're cash flow positive and you have profits and you have dividends that you want to distribute.
I think we have time for one last good question. You have a good question, right?
I think so. Okay, so I recently got some legal advice, and we registered our company as an LLC. However, we're going to be going after funding probably within the next 2 to 3 months. How difficult is it to go and move your company from an LLC to a C Corp? How long does it take, and what is the cost involved?
So the answer to that question depends on a couple of factors. First, what state you are already incorporated in.
Delaware.
And you want to move to a Delaware corporation?
Yes.
Okay. And we also look at what the company has gone through up until now. So do you have assets? Do you have liabilities? Do you have things like that? So based on that, there's one of 2 options. You can do a simple conversion from an LLC to a corporation. If it's as simple as just moving over. The other thing that we do is a reverse merger, which we probably don't need to do because it's in the same state. So to answer your question as to how long it takes, it's probably less than a week from the time you file to get the documents back, but you can expedite it if necessary. They have options there.
Thank you.
Well, let's hear it for Roger, Sheath, and Steve.
Well, before we go,
Oh, actually, Roger's got something else to say.
a couple of commercial announcements here. On the back, you'll find some handouts. One is the Royce Law Incorporator. It's an online incorporation tool. If you haven't incorporated it yet or formed your LLC, and if you'd like to, we've got a way of doing it online. It's dirt cheap, and you get an hour of attorney time with it. So that's our incorporator. Secondly, the second and last thing I want to let you know is we produce a tremendous amount of content. We do stuff like this all the time. In fact, we're doing 4 panels like this week. And we post it all on royceuniversity.com. And if you can leave me a card or sign up or leave a card in the back, in that big fishbowl back there, you can get on our mailing list. We have a webinar tomorrow, for example, on the gig economy. You know about the gig economy? We've been doing a whole series. Tax issues, regulatory issues, business issues. Tomorrow is employment issues in the gig economy. So make sure you get on our list so you can participate in our webinars, hear about our awesome events, and subscribe to our newsletter. Okay.
Let's hear it for Roger, Sheath, and Steve.
Yay.
So they'll all stick around for a few minutes. You can chat with them one-on-one, and they'll answer questions. They're not billing. Right. Anyway, thanks for coming. See you next time.